Act now, recast the selection process of the ECs. A multi-institutional, bipartisan committee will ensure a transparent exercise, given the quasi-judicial nature of the ECI. Reports of the Chief Election Commissioner (CEC) and his election commissioner colleagues, attending an informal meeting with the Principal Secretary to the Prime Minister, late last year, has brought renewed focus on the independence and the impartiality of the Election Commission of India (ECI). The CEC's initial hesitation when summoned was appropriate given that the ECI is a constitutionally mandated body that should maintain its distance from the executive, in perception and reality. Charges leveled. Over the last 7 years, the ECI has faced multiple accusations of favouring the ruling Bharatiya Janata Party (BJP). For instance, the Citizens Commission on Elections (CCE), chaired by the retired Supreme Court Judge, Justice Madan B. Lokur, in its report titled, An Inquiry into India's Election System, has highlighted several instances of inaction on the part of the ECI while conducting the 2019 general election. The government was also accused of hounding now former Election Commissioner Ashok Lavasa when he favoured taking action against the Prime Minister for violations of electoral codes of conduct. Given that the ECI is the institutional keystone holding up the edifice of Indian democracy, we suggest that changes in the appointment process for election commissioners can strengthen the ECI's independence, neutrality and transparency. The appointment of election commissioners falls within the purview of Article 324(2) of the Constitution, which establishes the institution. Pertinently, it contains a subject to clause which provides that both the number and tenure of the election commissioners shall be subject to the provisions of any law made in that behalf by Parliament, be made by the President. This subject to clause was introduced, in the words of Dr. R. Ambedkar, to prevent either a fool or knave or a person who is likely to be under the thumb of the executive. It was left to Parliament to enact legislation regarding the appointment of election commissioners. Apart from enacting a law in 1991, which was subsequently amended to enlarge the number of election commissioners from 1 to 3, Parliament has so far not enacted any changes to the appointment process. The judiciary could act. In the face of legislative inaction, there is now a possibility that the judiciary will force Parliament's hand. 3 writ petitions, with one pending since 2015, are urging the Supreme Court to declare that the current practice of appointment of election commissioners by the centre violates Articles 14, 324(2) and democracy as a basic feature of the Constitution. These petitions argue for an independent system for appointment of election commissioners, as recommended by previous Law Commission and various committee reports. In 1975, the Justice Tarkan Committee recommended that election commissioners be appointed on the advice of a committee comprising the Prime Minister, the Lok Sabha opposition leader and the Chief Justice of India. This was reiterated by the Dinesh Goswami Committee in 1990 and the Law Commission in 2015. The fourth report 2007 of the Second Administrative Reforms Commission additionally recommended that the Law Minister and the Deputy Chairman of the Rajya Sabha be included in such a collegium. The nature of the ECI. Precedent does exist in the case of Roya Matthew vs. South Indian Bank Limited, to argue against the executive being the sole appointer for a quasi-judicial body. The pending writ petitions, therefore, argue that the Election Commission is not only responsible for conducting free and fair elections but it also renders a quasi-judicial function between the various political parties including the ruling government and other parties. Accordingly, the executive cannot be a sole participant in the appointment of members of Election Commission as it gives unfettered discretion to the ruling party to choose someone whose loyalty to it is ensured and thereby renders the selection process vulnerable to manipulation. Hence, establishing a multi-institutional, bipartisan committee for the fair and transparent selection of election commissioners can enhance the perceived and actual independence of the ECI. Such a procedure is already followed with regard to other constitutional and statutory authorities such as the Chief Information Commissioner, the Lokpal, the Central Vigilance Commissioner, and the Director of the Central Bureau of Investigation. The quasi-judicial nature of the ECI's functions makes it especially important that the appointments process conform to the strictest democratic principles. The executive's role in the current appointment process has come under judicial scrutiny over its lack of transparency. Anup Baranwal vs. Union of India, Ministry of Law and Justice Secretary, WPC, 104/2015, which has been pending since 2015, and referred to a constitution bench in 2018, has raised this very demand for a collegium system for the ECI. Even though it was listed multiple times in 2020, it is yet to reach the hearing stage. A bench comprising the then Chief Justice of India, J.S. Kehar, and Justice D.Y. Chandrachud had also noted in 2017 that the election commissioners supervise and hold elections across the country, and this is the significance of their office, and their selection has to be made in the most transparent manner. The bench referred to the mandate of Article 324(2) of the Constitution to state that it is expected from Parliament to make the law, but it has not been made. Advice for Parliament. Parliament would do well to preempt judicial strictures by going ahead and formulating a law that establishes a multi-institutional, bipartisan collegium to select election commissioners. Separation of powers is the gold standard for governments across the world. The ECI's constitutional responsibilities require a fair and transparent appointment process that is beyond reproach, which will reaffirm our faith in this vital pillar of our polity. The existing veil over the appointment process of election commissioners potentially undermines the very structure on which our democratic aspirations rest.